In this class we're going to consider contract law. Let's start with what is a contract. Well, according to Lawson 1998, a contract is a legally binding agreement made between two or more persons by which rights are acquired by one or more for acts or forbearances on the part of the others. So a contract is an agreement made between two or more persons. Let's say there are two. So A and B can have a contract. And this contract will state that one has rights in return for acts or forbearances on the part of the other. Mere domestic or social arrangements are usually not intended as binding and therefore are not contracts. So gifts and gestures at home or with friends usually are not taken as contracts. There has to be what we call intention for a contract to come into existence. But back to the first part of this definition here. A contract is a legally binding agreement made between two or more persons by which one of them has rights and the other acts or promises not to act in return. So there are two parts to it. Businesses are constantly engaged in making contracts, either with suppliers, customers, employees, and advisors. So business is broadly run on the basis of contract. A contract is an agreement between two or more individuals that is legally binding, and these individuals are known as the parties. So a party to a contract is one of the individuals named in the contract. For a contract to take form, it's not necessary for it to be in writing. A conversation between parties can bring a contract into existence. In fact, custom and habit can bring a contract into existence. If something is performed in the same way for a long period of time, if some act is performed in the same way for a long period of time, it could imply a contract. It's a complex piece of law, but it's very important in the context of business that we understand this. A legally binding contract allows each party to take the opposite party to court if there's a breach of contract. So if one party does not do what he or her has said in the contract, the other one may bring that party to court and sue them. Let's go further into it. Let's see the classification of contract. Well, there are two types in this context. We have specialty and simple contracts. And let's start with specialty. These are formal contracts in law. This is where both parties to the contract go and get a formal document drawn up, legal document, and they sign it and they follow the rules for making a contract. This is usually in regards to various specialty contracts for various special situations. For example, conveyancing of land, lease of a property, or even articles in a partnership. If people are setting up a business together in a partnership, they may have some sort of contract between them, and it's formally drawn up. It also includes contracts by deed. Deed means written. The deed must be signed, sealed and delivered. It must be signed, so it shows that the parties agree to it. It must be sealed, so it's not tampered with, it's not altered, or there's no cheating. And it must be delivered. Both sides must have a copy. The deed must be handed over to the other party, agent or solicitor. So it must be delivered. The deed will only come into force when specific conditions are fulfilled. So it depends on what the contract states. It doesn't necessarily come into force the moment it's delivered. It may be later when something in the contract is delivered or is enacted. So those would be specialty contracts. Let's go back and have a look at simple contracts. These contracts usually can be made orally or in writing, generally speaking in writing, but they could be implied by behaviour. As I said, if an act is carried out, an economic act is carried out over a long period of time, and all the parties to the act seem to agree with it, there could be an implied contract. It's up to the courts to decide. An express contract is all the terms within a contract are stated in words by the parties. Now, that's an expressed contract. It means that the terms are very clear. There's no ambiguity about it. An implied contract, the terms are not expressed but exists based on circumstances of the parties. So an implied contract, it's not worded, it's not written down, but the behaviour of the parties, custom and habit, what's been happening for a long time, this sort of thing can be taken into account, and there is an implied contract between them. So simple contracts come in those forms. It's also possible to have a different classification, bilateral and unilateral contracts. Bilateral, two sides to the contract. Unilateral, oddly enough, one side. We'll see how it works in a second. Let's look at bilateral for a start. It's a process of exchanging promises by both parties. So the contract comes into existence, or in the process of coming into existence, by both parties making promises to each other regarding some economic transaction or some code of behaviour. This is nothing to do with private lives or family lives or that sort of thing. This is not based on relationships, personal relationships. This is a process of exchange. It involves exchange. It involves normally economic exchange. But both parties must make a promise. Now, bilateral contracts arise when one party decides to do something in return for an action by the other party. So, putting it simply, I will build your house if you pay me some sum of money. Now we've got both sides here involved in this transaction, and I've promised to build your house and you've promised to pay me some money, and we agree upon this, and we can write it down. We can turn it into a contract. In regards for a contract for the sale of goods, the buyer agrees to pay the price of the goods and the seller agrees to deliver the goods. There are two sides. You agree to pay and the seller agrees to deliver the goods. Let's go back to unilateral contracts. Now, a unilateral contract arises in a situation where one party promises to do something in return for a specific act from the other party, rather than a promise. Now, if one person promises to do something, the other person must do something as well. It's not a promise that has to be met in the future, as in the case of me promising to build your house and you promising to pay me some sum of money, perhaps when the house is completed. Now, a unilateral one is, I promise to do something if you do something. For example, Tom has lost his mobile phone. he decides to advertise a reward to anyone who finds his phone. Peter has seen the offer, finds the phone and returns it to Tom. Tom now is obliged to give Peter his reward as promised. So Tom set up all the conditions here for a contract. Tom promised to pay someone if they found his phone. But Peter found the phone, so Peter must be rewarded. There was a contract. And there's also a very famous case called Carroll and the Carbolic Smoke Bowl. Very old case, but see if we can have a look at it. This comes from Morrison, 2009, from his book. Essentially what happened here was the defendants were proprietors of, this is back in the 1800s, the defendants were proprietors of the Carbolic Smoke Bowl, a medicinal preparation. So it was meant to be good for you. The company was very confident about its product, and it advertised in the newspapers that anyone who used the bowl 3 times a day for a 2-week period and contracted influenza would be rewarded with £100. So they're very confident about this medication. If you took it, the bowl 3 times a day for 2 weeks, you would not get influenza. Further, to demonstrate the company's sincerity, they had deposited £1,000 in a local bank to satisfy any claims. So they're very confident about this. £1,000 back in the 1800s was a lot of money. Now the claimant, Mrs. Carroll, on the faith of this advertisement, she really believed in the advertisement. She bought one of the balls and used it as directed. However, she got influenza, and therefore she claimed the reward. The company, the Carbolic Smoke Ball Company, did not want to pay the £100 as argued in the court, and they said that there was no contract. So it went through the legal system, and eventually the Court of Appeal held that there was a valid contract. The £1,000 being placed in the bank demonstrated that the company's sincerity in paying the £100 identified in the advertisement. Carroll's acceptance was evidence through her using the product, her conduct, and there was nothing in the advertisement that required a specific form of acceptance to be notified to the company. So she used it as required, as directed, and she didn't have to tell the company that she was using it as directed. Therefore, the advertisement could be accepted by anyone who saw the advertisement and purchased and used as directed the product. In other words, there was a contract. So it's possible to have a unilateral contract. In this case, the company had set it up. They had set it up through the advertisement, through putting the £1,000 into the bank and offering to pay £100 to anyone who got influenza if they had used their medicine correctly. She had used the medicine correctly. She had got influenza. They had put the £1,000 in the bank. The court said that is evidence of their sincerity, and the contract was valid. But it was a one-sided contract in that sense. They had put the advertisement in. Anybody who read the advertisement took the medication as directed, were living out the other side of the contract. Now let's look at the elements of a contract. There are various elements that have to be met before a contract exists. And the courts are very stringent about this. All of the elements must be in place. Everything must be, all the boxes must be ticked. Otherwise, it's not a valid contract and will not be enforced. For a contract to be valid, it must contain the following. First of all, there must be an offer. Now, there are two parties here. The offerer, the person making the offer, and the offeree, the one who's receiving the offer. And the offer must be accepted. There must be an offer, and each of them must understand the offer. It must be a clear offer. It must be unambiguous. Both sides must understand the offer. What is the contract going to be about? I just found a definition of offeree in a website and included it here. It's a person or entity to whom an offer to enter into a contract is made by another, the offeror. I felt that the terms offerer and offeree were a little vague. However, back to the contract. There must be an offer. That's the point. And the offer must be accepted for the contract to exist. There must be an offer, and it must be freely accepted. There can't be force, or there can't be coercion of any form to get the other party to accept the offer. It must be complete and unconditional acceptance of the terms identified in the offer by both offeror and offeree. And the terms can be in writing, or it can be oral. It can be spoken. But so far we have two parts to a contract. We have the offer, which must be clear, and we have acceptance. Both must freely accept it. No force involved. Next, there must be what's known as consideration. Each party bound in a contract must receive equal benefits. It must appear a good deal to both parties. They must be willing to see out this contract. So the terms of the contract must induce them to see it out. Consideration is an interesting one. Go back to the example I gave you earlier about me building you a house and you paying me for it. Let's say I offer to build your house and you therefore say you will pay me £100,000. Just take any figure. Let's say £100,000 in exchange for the house. Now, that's your consideration. You might say, okay, I'll pay the £100,000 in two parts. I'll pay you £50,000 at the start, and I'll pay you £50,000 when the house is completed. That's consideration. The fact that you've paid the £50,000 means I must live out my side and provide the house according to the specifications that I've agreed with you in the contract. If I don't build a house, I will have £50,000 belonging to you. I will have broken the contract and you can take me to court. So the consideration is a way of ensuring that the contract is delivered. Now, an interesting one here is that the courts are not really interested in the value of the consideration. I could say I will build you this fabulous house in exchange for £5. Now, in which case I have made an absolutely ridiculous deal. But if you pay the £5, we have a contract. And the courts would consider it as a contract. I've just made a very bad deal. So the amount of the contract the courts do not get involved with. The fact that there is consideration, that's what they're after. Sometimes in English law we have all sorts of interesting little situations where excuse me, a contract may be deemed to be in place even though the consideration was very small, sometimes called a peppercorn. A peppercorn consideration. A peppercorn is a very small seed, a very small sum of money nowadays. And you will get you get people drawing contracts who are really giving away the usage of something for a very small sum. People may rent their property, for example, for a very small sum. There are some examples of cricket clubs who rent the cricket ground from the local council in return for a very small sum, perhaps £1 a year. The council are happy to have a cricket club, the cricket club are happy to have the ground, both sides are happy. There is a contract, both sides have security because they have a contract, but the consideration is only a very small sum of money. In America, they're getting a bit more worried about the use of this because they think it can lead to abuse and it can lead to shams. It can lead to covering up perhaps even illegal behavior. So I think the state courts in Texas have got particular problems about contracts with small consideration. But it varies across America. Different states have different views of it. But as far as we're concerned, most countries who have similar legal systems to the United Kingdom, the consideration is not investigated or considered by the courts. It's just whether there is consideration or not, whether both sides agree that there will be a certain sum paid if something else happens. There certainly must be the terms of the contract. There must be certainty about them. They must be understood. They must be clearly understood by all. There's no contract if the terms are ambiguous or if they're open to interpretation. Back to the house. If I said I will build you a house and I built a doll's house, well, that would be completely silly. So the specifications for the house must be written down. The contract could be quite elaborate. It may include plans for the house, the dimensions of the house, the types of material used. And the consideration would also be written in, that you will pay the consideration in return for me building the house. You will pay it on a certain date. And you'll pay the final one on a certain date, and on that date I will hand over the house to you. There's certainty in the terms. So just to review these, because these are very important in the law of contract, there are 5 parts. There's the offer. There must be an offer for the contract. There must be acceptance of the offer, free, fair, open acceptance. There must be consideration. In other words, there are 2 sides to it and each side is putting something in. I offer to build a house for you, you offer to pay me a certain sum of money. If we agree, we draw the contract. And there's an intention for us to draw this contract. We agree we're going to have this contract. We agree that we're going to be bound to deliver each side of the contract. I'm bound to deliver your house, you are bound to pay me the sum that you've agreed. And there's certainty about the terms. We both know exactly what we're signing to. There's no ambiguity, it's not open to interpretation, it's clear. So that's an introduction to contract. There's a lot more to be said about it and a lot more to read about this, but for the moment that's our introduction to contract. There's the 2 references that I've used extensively in preparation of this, and that just about concludes this class. So thank you for watching.